And I think if you look at the tax consequences and link it to immigration, it's quite important that there's a tie between the two. For example, people coming to work in South Africa, they arrive here without a proper work permit or no work permit at all, start work.
Does that often happen?
It often happens even more recently because of the need of people. So it's
Okay.
the people just arrive.
On an emergency basis, people arrive to do
Being
work.
flown in, they arrive to start working. And if you look at the tax side of it, the moment you start working here, from that date on, you are liable for tax in South Africa.
Okay.
And then the request comes through to say, but let's start the tax when the guy started work permits being approved. And that might be 3 months down the track.
So it could take anything to 3 months to get that work
Yeah,
permit.
so obviously there's a discrepancy there, and that could be a problem for a company. From an immigration point of view, a person working without a work permit, that person could be deported, could be penalties for the company. And then once again, from a tax point of view, if you do start the tax date when the work permit's approved, this person already worked here 3 or 4 months, we were supposed to be liable for tax in South Africa. And that's where the difficulties arise for companies, especially now recently, where the people are flown on an emergency basis on the projects they have to work on, and that creates big problems and exposure for the company.
Now Kemp, how should companies go about this? I mean, it happens in this country where there is an emergency situation and you want to bring a consultant in to help out immediately. What should companies be doing?
I know it's difficult, but companies do know relatively in advance what needs they have in the resources department. And once they start talking about it, they should start doing their homework on the immigration side specifically. Because of immigration issues and the struggle of the departments to get the work permit through intercompany transfers, they must do their homework up front as much as possible.
Now this obviously only affects people that you're going to take in your employ. It doesn't affect independent contractors that you would hire from a company based in London, for instance, to come and fix a short-term problem that you have.
No, it's more applicable to the people you're going to employ in your own company. If you get a consultant on a week or two basis, different rules apply, but that's not the issue at the moment, because normally that person won't be taxable in terms of a DTA, double tax agreement, if that's applicable. So it's more for people coming here on 6 months, year, 2-year contracts, being employed by local companies.
Now, in terms of South Africans going abroad, what are the issues that face corporations and businesses in South Africa? If we're wanting to send somebody, let's say, up to Kenya or up to London or into New York to go and perform work services there?
Outbound people, I think the same applies. Once again, immigration is quite important in those countries, but it's much easier there, for example, in the first world country to get those visas, etc. Going into Africa, for example, it might be more difficult, but I think once again, immigration is quite important, that you get your house in order in that country. And then from a tax perspective, it's also quite important that they do know what's required of them from a compliance side locally. They still have to submit returns, for example, here, although they might be away for 6 months or a year, and what their tax requirements are in that foreign country.
Now, do the double tax treaties play any role? I mean, if somebody were to come from the United States to work on a short-term contract as an employee in South Africa and the other way around, is there something there out of the double tax treaty that will either subject them to tax in the United States or in South Africa, as the case may be?
Definitely, Daniel. Most of the double tax agreements make provisions for short-term business, and normally the requirement is 183 days. And then there is relief. If you work in South Africa, you can get relief if you less than 183 days in South Africa.
So the whole idea is that if you're a South African, from a South African point of view, if there isn't a double tax treaty relief, you will at least get some sort of tax credit for tax that you've paid abroad.
Yes.
Just lastly, is there anything else that employers out there should be made aware of? Any particular technique that makes this a lot easier by using an intermediate company or anything like that?
Yeah, definitely intermediate companies play quite a big role, but I think mostly for corporates at this stage is they must make sure they've got proper relocation policies in place.
Thank you very much, Kemp, for that useful information. Those of you who would like to read more about this interview, please look out for the next issue of the Tax Talk magazine or log on to their website, taxtalk.co.za. They can also be reached on 0861 829 825. Until next week, goodbye.